Hey, everybody, it's attorney Veronica McClendon, the owner and CEO of McClendon Law and Consulting located in Macon, Georgia. I want to talk to y'all today about something that is a common thing that I see with some of my clients and people that I've encountered over the years as a probate attorney, as an estate planning attorney. A situation where they will have a loved one who has passed away, and once people start hearing that that person has died, then creditors start sending in their notices. They start saying, hey, so and so owes this money. Perhaps they were in a hospital at the time of their death and they may have accrued hospital bills. There's the funeral expenses. There are all kinds of expenses that may come up. And people are submitting their claims to you, sending bills to you, and saying, hey, you need to pay these things on behalf of your loved one. Well, the question is, should you start paying those bills as soon as they come so that you can clear your loved one's name? And I'm going to say no, that's not something that I would recommend that you do. There are a few reasons for that, and we'll get into those. The first reason is because you don't know what all claims are going to come in. You may just get one or two bills at first. They may seem pretty manageable, and you think, okay, I can pay these. Well, then later, more and more come in, and you realize that there are a lot of bills coming in, and you don't know what else to expect. You don't know if more are coming, how much they're going to cost, if you're going to have enough money to pay those expenses. So that's one reason. Another reason is that when a loved one dies, more than likely their bills are not your bills. Unless you have agreed to pay their bills on their behalf. I don't know why the word is slipping my mind right now, but if you have agreed to pay their bills, if you were a co-signer, or if you somehow assume responsibility for their bills, yes, in that situation, you might be responsible for helping to pay their bills. But in other situations, if they are a loved one and it's not someone that you were financially responsible for, then you are not necessarily responsible for paying their medical bills or any kind of expenses that come about. Now, if they're a minor child or a person in relationship to you like that, that might be a little different, or even a spouse, depending on what state that you're in. There could be situations where you would be responsible, but I definitely would advise you to wait until you can talk with your attorney to see if those are debts that you would need to pay out of your own pocket. Now, it's one thing if you have money from that deceased family member and you're saying, okay, do I have to use this money to pay the bills? Well, perhaps you might have to at some point, but I don't advise that you do it immediately. And so for the first reason, like I said, you don't want to run out of money. Second reason, they may not be your bills. But the third reason is that there are orders of priorities with debts. So there might be some debts that are required by law to be paid first. And it would have been good for me to have the order of priority for the state of Georgia, but I don't have it in front of me. But I will say that the government is one of the people at the top. They're going to get their money before some other groups. Funeral home expenses, funeral expenses, those are some of the debts that go closer to the top in terms of priority. But there's some like credit card debts and things like that that will be a lower priority. And so you want to make sure that you prioritize the debts in the order that they should be prioritized, and make sure that you kind of process everything in its proper order. With Georgia, the state of Georgia, we have a process that is followed before you need to start paying off debts. The first thing you want to do is file your petition to become the representative of the estate. Usually it's going to be a petition for letters of administration if the person died without a will, or if they died with the will, it would be a petition for letters testamentary. But you need to file that petition and become the legal representative for the estate before you start paying bills. The other thing that you would need to do here in Georgia specifically, you have to file a notice to debtors and creditors in a newspaper. That's a legal requirement. It's something that you need to do as the administrator or the executor of the estate. And what you're doing is saying, hey, if the person whose estate I represent owes you money, or if you owe them money, then it's your time to let us know so that we can get a sense of who all we owe or who all owes us. so that we can decide how we're going to get these bills paid. So you want to file that notice to debtors and creditors because, again, like I mentioned, sometimes there are bills that come in later. And once you file that notice to debtors and creditors, that gives everybody an opportunity to submit their claims, and it starts the clock running. That notice to debtors and creditors in Georgia has to run for 4 weeks. And then once it runs for 4 weeks, and there's an additional 90 days that you have to give time to the creditors to submit their claims. So once that time period is up, that's a good time to start paying those debts off because you have given everybody a chance to see who says that your estate owes them money, and you can kind of rank everything according to that order of priority, and then see what money you have in the estate to take care of those expenses. And once you know all of the information, you can decide how you're going to pay it back. You might have enough money in the estate to pay everything off, so that's one thing that could be good. Or if you don't have enough money in the estate to pay everything off, you might have to do a proration where you say, okay, everybody is going to have to get 70% of what the decedent owed them. They might not get 100%, or they might get 95%. Whatever that percentage is, you want to be consistent with all of the creditors so that everybody is getting a certain percentage of the estate, of what they were owed by the estate. And also, it's a good idea to try to negotiate with the creditors. Sometimes they will negotiate with you because they want to get paid something. And I haven't seen a situation so far where a creditor was not willing to negotiate for half of the money. They might take half. They might take 60%. They might take 70%. It really depends on the creditor, but it's worth a shot to ask them if they would be willing to reduce the debt if they can get a pay in full promise from you. There's one more thing I want to mention that's very, very important, that there are situations where the surviving spouse and where minor children might be able to take priority over creditors' claims. And so you don't want to go and pay all the creditors and then the surviving spouse or the surviving minor child could have gotten that money to help provide for their expenses because they depended on the deceased person to help with their expenses. So in those kind of situations, you don't want to pay the creditors off and then later find out, oh, the spouse could have gotten some assets before the creditors did. Or you don't want to have it where a minor child is being left out before creditors are paid. So those are some reasons why you want to avoid just paying off debts. A lot of times people are really eager to pay off their loved ones' debts. They feel like they want to clear their name, and that's good. It feels good to do that, but sometimes you just don't have to do that because they don't have a reputation to keep anymore. And I know that sounds that could be a little crass or a little straightforward, but it's true. It's their name being cleared does nothing good for them, and in trying to clear their name might take money away from you that you could use to help your life to be better. And I want to say one more thing about this. I've had situations where people will take life insurance money that's written out to them. So their loved one took out a life insurance policy and put one of their children or a spouse or someone in the family. They put them as a beneficiary to life insurance. So when they died, that money went straight to their loved one. But then the loved one took the money and paid off the debts of the deceased person. And you don't have to do that. It's your money. And so I do encourage people to be cautious about that, because when the money goes to you as a life insurance payout, then that's your money. It's not money that goes back to the estate of the person who had the life insurance. I will say that's not a blanket statement. I'm sure there's a situation where a state could have a law that says differently, but definitely you want to talk to an attorney before you just start paying things off, because you could be paying money that your family could be benefiting from and helping you to recover financially after losing someone whose finances you've depended on. So just want to give you those tips and just really encourage everybody that it could be worthwhile to talk to an attorney, even if you just do a consultation where you talk with them for about an hour, ask some questions. Make sure that you're following protocol before you just start doing things, because later it's a lot harder to fix things that you may have done outside of a good legal counsel. So just a little tip for you all, and I hope that if y'all have questions or any comments that you will leave them in the chat. Thank you so much. Make sure you subscribe and have a wonderful day.